Welcome to the Untitled Legal Attempt. My name is George Sintankoma Lipilo. Thank you for tuning in. So this week's case is the Zambia Privatisation Agency versus James Matale 1996 Supreme Court Judgment. The case in hand looked at two important questions. One related to termination, payment in lieu of notice. Does such constitute a lawful way of terminating a contract of employment? The other was where the notice clause is not provided for in a contract or in an oral contract. What therefore is the reasonable period in which you can provide that notice? So when we get back, we'll dive right into the case. For now, let us finish the music in the background. Okay, welcome back. Oh, alright, let us head right into the brief facts of the case. James Matale and the Zambia Privatisation Agency entered into a contract of service on 11th November 1992. It was in relation to the fact that the respondent, James Mutale, was given a job as the director of the Zambia Privatisation Agency. He was the first director, FD, Baba Pirinchito. And during that period, the employment contract that was sent to Matale stated that they would obviously have a subsisting document, a contract of service. However, it is common cause, and it's very important for you to note that at no time was there a contract, visible contract. It was based on, obviously, an oral contract and the relationship of master-servant. Now, let's fast forward to 8th September 1994. Now, it's barely just not less than 2 years into his 3-year contract. James Matale is director role is terminated with immediate effect on 8th September 1994. Now remember, whilst that termination was happening, there was still no actual physical contract copy that existed between the parties. Now, allow me to read from the actual court case where they had stated the letter. I will not copy everything. What am I saying? Copy. I will not state everything. I'll just pick out the important aspects. The letter reads as follows: Dear Mr. Matale, following the adoption of the Pricewaterhouse Restructuring Report by the Zambia Privatization Board, it has become necessary to reorganize top administration of the agency. End of quote. The letter also goes on to say that his services were terminated with immediate effect, and you have to hand over all documents and all properties that belong to the Zambia National Privatization Agency. No, the Zambia Privatization Agency to Mr. Stephen Mwamba. Okay? Now, upon that contract being terminated with immediate effect, the respondent, James Matale in the Supreme Court, was paid 3 months' salary in lieu of notice. So they didn't give him notice of termination because he had to save out. If they gave him a notice of termination in relation to the contract of service, he had to save out the whole 3 months, then the contract would be terminated. He will no longer discharge obligations for the Zambia Privatization Agency, but they paid him the 3 months period, okay? Meaning his contract immediately ended because they had paid him that period. I'm just giving an example. In this instance, the other thing you must note is that there was no clause pertaining to the termination of a contract or notice in lieu, but they paid him a 3 months salary in replacement of notice of termination. Okay? Now, James Matale, unhappy with that, went to the Industrial Relations Court. Now, when he went to the Industrial Relations Court, he brought out two grounds. One of the grounds was the fact that because of the Price Waterhouse report, he felt that he was being discriminated because it did not recommend for his dismissal, and the dismissal had no basis. Now, the court threw out that argument to say the termination of his employment, which was based on discrimination, that ground was not proved on a balance of probability. So he did not show to say that he was discriminated based on the grounds stated in Section 1081 of the Industrial and Labor Relations Act, namely sex, race, matrimonial status, religion. So he did not prove any of these as a key factor in discrimination. So that was thrown out. However, the court did conclude to say the manner in how the Zambia Privatization Agency terminated James Matale's contract, or Matale's contract, was actually illegal, unlawful, unjust, and they ordered that he be paid for the remaining period of the contract. So meaning from the day of the unlawful termination up to the date that the contract ended. So in short, to be paid. In short, they'll be paying for 3 years, the whole 3 years. Yeah, because the unlawful contract takes you back. It's like nothing ever happened. So, when we get back, we will look at the Zambia Privatization Agency before the Supreme Court of Zambia and James Matale as the respondent after this huge money has been given to this FD, the director. I bet he was very happy. I'm just joking. Alright, we'll be back shortly. For now, some music. Okay, welcome back. So, the Zambia Privatization Agency went before the Supreme Court of Zambia, and the respondent was James Matale. Obviously, by now, maybe Ari and Indarama. So, the main contention that was before the Supreme Court, and obviously what the Zambia Privatization was arguing, was to say payment in lieu of notice was lawful, or was the lawful way of terminating the contract. Okay? That was the argument. Now, the two most important questions before the Supreme Court of Zambia were: one, was the payment in lieu of notice a right way of terminating the contract of employment? Or we could put it, did it constitute a lawful way of terminating a contract of employment? And also, remember, there was no notice clause of termination. So, how then, therefore, would you define, or would you be able to identify the reasonable notice period in which to determine the notice to be given? So, the court, first of all, agreed again with the Industrial Relations Court. The Supreme Court did agree with them by stating to say the ground in relation to discrimination, that one was a non-starter. They stated, and I quote, "We have no hesitation in agreeing with the Industrial Relations Court that the respondent did not prove discrimination, as none of the reasons for discrimination as set out in Section 1081 had been established." So that was thrown aside. Now the court also noted to say the fact that there was no notice clause, or as the court put it, it was common cause that the contract of employment in the instant case did not provide for the termination of employment by notice or payment in lieu of notice. End of quote. So having noted that, the court stated that they, however, accepted the relationship between the parties. Meaning there was a master and servant relationship between the parties. So as a result of that master and servant relationship, therefore, the manner in how the Zambia Privatization Agency terminated the contract against James Mutale was legal. They stated, and I quote, let me look for that specific part. Yes, they stated, and I quote, "The payment in lieu of notice was a proper and a lawful way of terminating the respondent's employment. Now, pay particular attention. The court did state that you can pay an individual rather than provide them notice of termination. So when you pay them, termination immediate, rather than them working in that notice period and then it terminates. So clearly there must be a termination clause that must be provided for how a contract can be terminated. Now in here there was no notice clause of termination. The Supreme Court stated that does not matter. The parties can still terminate the contract even though there is no notice clause. So even if anyone has no notice clause in a contract, you can still terminate it. They also stated that where there is no clause, in order for you to determine the notice clause, because it's not expressly provided for, the notice period must be determined by what is a reasonable notice. Now, we don't know what a reasonable notice is because the Supreme Court says it varies from case to case. But in this case, they said a reasonable period in which you can terminate an active contract of employment could be 6 months. But it varies from case to case. So in Matale's case, he was the first director. This was a very important company. So they felt 6 months is a reasonable notice. Okay, where there is no actual notice clause. Yeah, they said that. And they stated this because he was the director. I keep on mentioning that. He had also no poor performance. And he was a all well-rounded employee of the company. So 6 months. So it could be less depending on your demeanor as well and how you behave, and also maybe the position, and also maybe, but it could be more if you find it difficult to find a job. So alright, so what this meant was now that the Supreme Court had quashed the judgment of the Industrial Relations Court, okay, and therefore they stated that this was a legal way, okay, of terminating a contract in lieu of notice. But where there is no reason, where there is no express stipulation, you must now determine the reasonable notice, and you must look at all those facts. So what I also noted from this case was, in the event that you as the employer does terminate the contract, but you terminate it unlawfully, the salary that, or the relief that can be sought by the employee will be one that will lead to them being paid for the remainder of the contract. But that's if you basically unlawfully terminate the contract without following the law. But in this instance, the notice period that was given, 6 months, because of the first director issue, was allowed. Okay, they had given him 3 months, so they had increased it to 6 months because that was a reasonable period, because there was no provision. If there's a provision and you follow that provision, it is fine, and you can payment in lieu of notice is allowed when it comes to termination of a contract. So you can either therefore terminate a contract by giving notice of termination, and once that notice closes, or once that notice has passed due to a fluxion of time, the contract will terminate, or you can pay that notice period, then the contract will terminate. Or in the event that there is no express provision, you must determine a reasonable contract. Now there's precedence that has been set, what you must follow and look at to say how you can reasonably determine the notice period. 6 months is considered to be a standard, but it could be less because reasonable notice varies or depends. So therefore, we have seen the importance of the Zambia Privatisation Agency versus James Matale when it comes to termination of a contract and when there is no express termination of a clause and what it can do. So thank you for listening. I've been your host, George Chintankwamali, and thank you for tuning into the podcast. See you next week for our part 2 of this employment law podcast.